This conference will now be recorded.
So this might be, if I can get enough views, we can monetize it. How's everybody doing today?
Good.
It's been a long time since I've been over here. I know I've been to this office a couple times, but it's probably pre-pandemic since I've been over here. For those of you who don't know, my name's Matt Beard, and I'm an attorney with Pitt and Frank. I brought Morgan with me, Morgan Norris. He is soon to be an attorney with Pitt and Frank. He took the bar exam, took in July? Yeah, he probably finds out next week or so. Okay. You know, if you come to our office in a month and he's nowhere to be found, you know the answer. I'm just kidding. I've had people work for me who had trouble with it, and they stayed with us. So Morgan will be fine.
It'll be all right, Morgan. Don't worry about it.
Yeah, that's right. Or if you come over specifically next week and land on the floor, it's because he passed. What we'll do, how we'll handle this, and the reason I think Allison might talk to Morgan, and I got pulled in just because being an attorney and doing this a long time, I know the subject matter. Cora Henderson and I teach a class similar to this at GWAR, and it's a 3-hour class. So what I've done for this, and we talk about, trust and powers of attorneys and everything. So what I've done with this is I've just kind of condensed it down to talking about an estate, a probate estate, and what you would need if you're taking a listing from somebody who's handling an estate, something like that. Kind of give you an idea. As we go through, it'll go much better if you have questions. I know everybody's eating and stuff, but if you have a question, just stop me at any point. All right.
This conference will now be recorded.
Move the slide.
Yeah, the first one's always the tough one, I think. Yep.
No, I'll do this. Does that work? There you go. All right. See, it's, anybody younger than, how old are you, Morgan? 20, 25, anybody under 25, that's, the tech. So first off, you'll hear these things referred to, as a decedent's estate. Okay, that's what you'll hear, us attorneys talk about it as. But when we talk about a decedent, all a decedent is a dead person. Okay, it's somebody who is deceased. So don't get alarmed with that word. Okay, when we were in law school, there was a dance they had every Halloween called the Decedent's Ball. So I mean, it's it's a ongoing joke. But what the decedent's estate is, it's created at the time of death. It contains all that person's property, okay, that they had at the time of their death. All right. So in simple terms, what happens during that estate is someone needs to collect the assets owned by the decedent. Then they need to pay whatever debts that decedent had at the time of death, okay, and then transfer any property of that decedent to the rightful person. So and the rightful person would be either determined by the laws or by the will, okay. Now who that someone is who's going to transfer that property can be your executor, executrix, your administrator, administratrix, or your administrator, WWA, administratrix, WWA. Basically, all the same thing. Okay, the differences between an executor and an administrator is that the executor is appointed via a will. They are named in the will. An administrator is someone who's appointed when there is no will. Okay, now what an executrix is versus an executor, an executrix is a female. Administratrix is a female, so that's all that is. So if you're a female who's been appointed, they'll call you an executrix. Now, question. Yeah.
If there's no will, does the administrator usually a state person, or do they?
Be whoever. What'll happen? And I'll talk about this, but what'll happen if there's no will? Typically, it's someone who's close to the family, maybe an heir, someone in the family, like a surviving spouse or surviving son, daughter, will go into the court and get appointed. It doesn't have to be though. Okay. It can be anybody kind of with an interest who is willing to petition the court. It technically, you don't see this too often, it technically could be a creditor. Okay, all you have to do is you have to fill out a petition, file that petition with the probate court, go into the probate court and argue your case why you should be appointed. And if a judge agrees with you, you'll get appointed. Okay, and like I said, 99 times out of 100, it's probably going to be somebody familial or somebody close to the decedent. Okay. Now this final one, this administrator WWA / administratrix WWA, what that WWA means with will annexed. So if I have a will, and in my will I name my wife the executrix, but then something happens and she can't serve as an executrix, and my son comes in and becomes the executor, he's technically not the executor because he wasn't named. He becomes the administrator at WWA. So it's basically an administrator is someone who wasn't named in the will, but there is a will. Does that make sense? And ultimately, it really doesn't matter. They have kind of the same powers. All right. All right. What does the personal representative do? The personal representative, the executor, the administrator, what do? Their practical responsibilities include gathering up all the assets, okay, of the decedent, obtaining information about the beneficiary, so who's getting those assets, okay, they would either be named in the will, collecting and arranging for payment of debts, okay, approving or disapproving creditors' claims, making sure estate taxes are calculated and paid if there are any. There's not generally not a lot of estate taxes usually unless it's a higher estate. And by high, I mean big money estate.
Yeah.
And then always assist the attorney for the estate. Okay. Now, this is basically, how many of y'all have ever acted as an administrator or an executor? Anybody ever had to do that? Yeah. Okay. Probate procedure is, I'm going to kind of give you an overview, I guess. That's the best way to do it. So you have someone who dies, you're named executor. Okay. What you'll do is you'll take that will to probate court, file a petition. The clerk in the probate court will set a hearing date. You'll show up on that hearing date. The judge at that point will take proof. If the will is self-proving, which means the will has been notarized with 2 witnesses, there's no need to take proof. If the will is not self-proving, you might need to bring witnesses who can prove that that is the will of the decedent. In other words, somebody who knew the decedent, who either maybe saw him sign or his handwriting or something. Okay? Once that's satisfactory to the judge will appoint you the executor. All right, from that point, what your role is, you have 60 days to file an inventory of the estate. What that means, you got to go around and find everything the decedent owned. Okay, so any bank accounts, cars, anything of that nature. Okay, real estate, if there is any. That's kind of what we're talking about. Okay.
I'm trying to mute these people.
Okay. So you'll file that inventory, basically telling the judge, telling the probate court, this is what we got. This is what we're dealing with. Okay. Typically, creditors come in at that point. Usually, or not usually, they have to come in within 6 months of when you file when you're appointed. All right. So a creditor come in and they'll file a claim. So say, when I died, I owed a bunch of money on my Capital One Visa. So Capital One will come in and say, hey, Matt, when he died, owed us $2,500, and they'll file a claim. And anybody else might file a claim. It's typically unsecured creditors. Your mortgage company's got a mortgage on the house. They typically won't file a claim because they've got the house to cover them, to secure them. Okay. After that, they file the claims, then what the executor will do over the next 6 months is liquidate those assets. So try to sell the cars, try to cash the stock, try to empty out the bank accounts, put everything into an estate account, liquidate it, okay, and then pay those debts, right? Pay Capital One, and then look at that will, determine who gets what, pay them off, but just give them their money that they deserve, pay them, and then file a final settlement with the court and close the estate. And typically, probate court likes to see this all happen within 1 year. That's a dream. Typically doesn't happen within a year, especially now with the pandemic and stuff. I think, and I don't do much probate work. I used to do a lot of it. I don't do much anymore. But typically what the probate courts are running on, I know just to get a hearing to be appointed might take 6 weeks. So they're not closing the estates out as quickly, I don't believe. Okay. Everybody kind of clear with the overview on how that works? All right.
But one quick question on that, because what comes up with us a lot is, so someone dies, of course they go in, maybe they have got, set the table with the probate court, maybe they haven't, but the first question is we want to sell the house.
Right.
Always.
Yeah.
And you can't.
Right. And I'm going to get to that.
Right.
Okay.
Some attorneys say you can
Some you can if they set the money in a trust, I
for
guess.
6 months.
Yeah. Correct. Creditors' rights. Yep. And we'll talk about that.
Okay.
Yeah. I just kind of want to give the overview on the probate procedure so you know. And of course, I'm not moving again now. So my arrow's not going here.
It does look like sitting still for long.
That's all right. There it is. All right. Kind of brought all this up. Probate estate, what it is, it's the assets that are gathered. Now, here's the thing about a probate estate, okay? The probate estate consists of probatable assets. So what a probatable asset is, it's usually a non-titled asset. All right. Not non-titled like real estate. Now, a titled car, vehicle like that will be probatable. Okay, depending on how the title works. A non-titled asset like your deed or like your real estate, which has a deed, the deed can determine how the property passes. What I'm getting at here is down at the bottom. You see where it says joint JTWRS versus TIC. All right, JTWRS, joint title with rights of survivorship. TIC, tenancy in common. Okay, so this is key. So if the property is titled Matt and Missy, that's my wife, for and during their joint lives with the remainder in fee simple to the survivor of them, that's JTWRS. So when I die, my real estate automatically passes to my wife, Missy. Automatic. Okay. Now, if it says to Matt, a 1/2 undivided interest, and to Missy, an 1/2 divided interest, that means Missy and I own as tenants in common. So we each own 50%. So my 50% probably probatable, depending on, you know, what's going on. Okay.
But couldn't you have your 50% like going to your son or something?
Depending on how I wrote it, yeah. I mean, and you'll see that. You won't see it too often. I would say when you have husband and wife, 90% of the time, you're just gonna see the joint title with rights of survivorship. Okay. Now, one thing about this, your will doesn't cover the disposition of property that's controlled by title and passes outside the probate estate. Now, what we get at here too, say you have a life insurance policy. Okay. Life insurance policy, in that policy sets out a beneficiary. I name Missy as my beneficiary in life insurance policy. That life insurance proceeds are not probatable. They don't end up going to my probate estate. They go into the named beneficiary. Similar type thing. Okay. Now, one thing I guess you need to know too is being realtors, y'all probably heard all about dower laws. You understand dower laws? If I own in Kentucky, if I own property in my name alone, all right, when I die, my wife, Missy, automatically has what's called a dower interest in that property. Okay, so she's got a 50% interest in that property, whether she's on title. Okay, if she's not on title, she's on title, she's got her title interest. But when she's not on title, she'll have what's called a dower interest. All right, so you have that to contend with as well. All right, so say I died, I owned a 50% interest. My wife owns a 50% interest. When I die before my wife. She has her 50% interest she already had. Then she has a 50% interest in my 50% interest. So she's got a 25% interest there. And then my other 25% interest could go according to the laws of intestate succession or according to my will. All right. Now, first thing.
Very confused?
Yeah. As we go, it'll probably get more confusing. Now, when I get to the end here, one thing we do have is I have a bunch of like scenarios, questions that we'll try to put it in kind of real life form for you so you can kind of see, okay, see what we're talking about. What you'll hear when there's a will, you'll hear that the person died testate. Okay, so if you ever hear that, if somebody calls you and says, yeah, I want you to list my dad's house. I don't know what this means, but the attorney said he died testate. This means he died with a will. So there's a will you need to be looking for. Okay. Now, when there is a will, all right, basically I kind of went over this with the probate procedure. All right, everything flows in. So all this top stuff we got flowing into the probate, okay? And then the bottom part is what's going out, taxes, fees, attorney fees, that type of thing, and then money to the beneficiaries.
What's the percentage that the administrator typically takes to manage a will?
There's a statutory percentage. I think they can take about 5%. Okay, but then also it can get real. I back up and let me tell you my history with this. I used to work for the public administrator in Jefferson County. What a public administrator does is when a general person cannot close an estate, say you're named executor and it's just a mess and you can't get the estate closed and it's been open for 2 years, the court might come in and remove you and appoint the public administrator, which is typically just an attorney in town. It was when I was there. So he was an attorney and I worked for him. And he doesn't know anybody. Okay, it's not his family. So he's going to take his fee. All right. And then one other thing you can do with those estates, he take his fee at the end, but then if it takes a long time to close and he has to invest the money, you know, say he's liquidating assets and putting them in the interest-bearing estate account, he can each year take 6% of the income as well. So you don't want to end up where you got a public administrator doing this.
How about bank? Because I see a lot of people put the bank in charge of their work.
Bank, they probably would take the 5% at the end.
They are.
Yeah, and that's not an attorney fee. That's a 5% fee. Like with your estate, when you handled an estate, was it for a family member?
Yes.
Did you take a fee?
No.
Yeah.
It was a trust. though.
Well, that's right. But you normally wouldn't. Like I named my mom's executor. When she passes away, hopefully no time soon, I'm not going to take a fee from her estate because I'd just be taking my brother's money and. But if you're, and I guess some people feel like, it's a status thing to have PNC Bank be their executor or something. They'll probably take a fee. So yeah.
It is one of those things when you say that, I mean, they deserve it. You think like it was a trust and they thought it had a streamline, it still took every bit of a year.
Oh, it's
a lot of work.
Well, just, God, I just talked about my mom, and I, she's in her 80s now, God love her. And I go to her house and I just look around and I'm like, oh my God, I don't even want to think about, I don't even want to think about, I'll be opening drawers and I'm sure I'll be like, oh, there's Dad's retirement. I wonder if she, so it.
So you think it's smart to have a co-administrator or what, just one person in charge?
I think it's smarter just to have one person in charge. And from what we do, typically what happens with us is when I have a realtor call them, when we take a deal and the realtor says, well, so-and-so and so-and-so are co-administrators, but so-and-so doesn't want to come. They don't want to come to the closing. So then I have to look at the will and say, or co-trustees or whatever. I have to look and see if they can act independently of each other. In other words, am I good with just having one of them come? Invariably, it doesn't say anything about that. So then I have to say, no, I need you both there. Well, then they're mad. Well, why do we both got to be there? And then it ends up being half mail away closing, and half of them are coming in person. And I just think it's easier just with the one, unless these two people, these two brothers or sisters or cousins or whatever, are just so harmonious and they just work so well together that it doesn't matter. But that's not usually the case. I mean, just to let you know, I do real estate for a reason. I've been an attorney for 26 years. When I got out of law school, I did a lot of that probate work. I did divorce work. I did regular lawsuit work. I defended some people on some things. I didn't like the divorce work was terrible. I mean, let me just tell you, when you're doing a divorce, it's like each day you're going in, you gotta be ready to fight. Basically, one time I'm in a mediation, I look around and I'm like, well, the other attorney hates my guts because he's on the other side trying to win. We're just going at it. The other client hates my guts because I represent her sleazeball ex-husband. My client hates my guts because he thinks I'm not doing anything for him. All right, because I'm not winning him. He's got to pay child support. Like that has anything to do with me. So everybody in this room, the judge hates my guts because she didn't want to be here either. She's like, just get this settled. So everybody in the room hated my guts. So I was like, I gotta get out of this. Did probate estates. I had an estate one time where I had two heirs in court. And they're fighting. Oh, I mean, when I say fighting, they were ready to come to blows over a beer stein that, when you pushed it, played When the Saints Come Marching. The sheriff had to put us in one of the side rooms, and they were yelling so loud. I'm like, I don't know what to do. The sheriff had to come in, tell them to calm down. Sheriff told him he was gonna arrest them, but they didn't calm down. And this was probably this mug. If it was current, I probably could have gone like Amazon and found it, for $15 and got it. But it just brings out the worst of people. Where real estate, that 5% of your deals, I'll sit in there and be ready to kill the people. But 95% of the time, buyers buying a house, they're happy. Sellers selling a house, they're happy. The realtors are happy. They've done their job. They're getting their commissions, and it's usually knock on wood, pretty good process.
I gotta say something funny and clearing it out. We had a horse trailer. My parents had a pretty good sized house, and they were World War II kind of hoarder.
Right, yeah.
Obviously. And about the third trip to the dump with the horse trailer, they asked him, where are you getting all this stuff?
Yeah.
So, yeah, that's the most of the big thing.
Well, my mom, my dad passed away about 5 or 6 years ago. And my mom has gotten to the point where she doesn't sleep in her bed anymore. She just sleeps on the couch. It's easier. So I'm like, well, I go up and look at her bed, and she's got papers stacked up on her bed too. So just you reach it. And my mom, when I was little, man, you didn't leave nothing on the kitchen table. She go, now it's like she got stuff laying there. And I'm 51, so in 30 years, I already told my kids I'll be doing the same thing. Just give me a break. All right, the executor. That's that's what we talked about. The executor is the person appointed the administrator, all right, or to administer the estate. He is not the administrator. Unless there's a valid objection, the judge will appoint that person. So when you're named the executor, you still got to go in and tell the judge you want to run the show, you want to be the executor. If say I'm named executor, my mom's will, and me and my brother don't get along, he can come to court and object, and then the judge will listen to the objections. Typically, though, the judge will take, what the will says and go that way, unless it can be proven, I'm a convicted felon, I steal money from bank accounts, then they might look the other way. The executor must ensure that the decedent's what they want to happen is carried out. All right. Now, if you have a will, this is where we get into important stuff. Okay. The will must be prorated. Okay. Probated. I didn't type this up, by the way.
I wasn't gonna say anything back there.
This is all Cora. All right. Y'all can tell her I said that. The will must be probated, not prorated. You're gonna talk to your client. Oh no, my will's gotta be prorated. I don't know what this probated stuff is. It says if the will contains, see this gray section, if the will contains a specific power to sell real estate, and it must specifically mention real estate or real property, only executor or the administrator with the will annexed is needed to convey the real estate, okay? And the proceeds at the closing will be made payable to the estate. So put it this way, if you're taking a listing, guy tells you, hey, mom died, taking a listing, all right, I want to sell a house, all right? What you would want to see from them, okay, you'd want to find out if they have been appointed the executor. So what they would have, all right, is they would have a sheet from the probate court called a certificate of qualification or an order of appointment. They usually are in conjunction with each other. You'll have one, you'll have the other. That shows they are the executor, they have power, okay? All right. Okay, and then
Says Descendant up there too.
Her kids must have been bothered when she was doing it.
I'm blame it on Kelly Human. It looks like something she would.
Well, I tried to get rid of, she has all these, you'll see them, all these little pictures and stuff, and I'm like, oh God. But there's a lot of them still in there.
Yeah.
So where was that? Oh,
Sorry.
that's okay. You gotta have that certificate of qualification or that order of appointment showing that they are the person named, they are the person who can sign your listing, who can sign your contract as the seller, okay? All right, get that, you're in good shape. What you might also want to look at, we'll look at this as it gets closer to closing, but you might want to look at it just to be safe. Get a copy of the will. Say, hey, let me see a copy of that will, and look for that language. Typically, there's one whole section of the will that lists the executor's powers. And it says the executor will have power to deal with any blah, 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 and sell any real estate or real property owned by me. And if it says sell property, that ain't good enough. Got to say real, okay?
And if you're not sure, send it over to Pitt and Frank for review.
Yeah.
Definitely ask for it, a copy of it.
Yeah. Because what you don't want to do is take the listing, work the deal, and then they're not even appointed. Or they don't have power of sale. Because if they don't have power of sale, you could put that in the listing, let people know that it could take a little bit of time to get to closing, okay? And I'm going to tell you why here in a minute if it doesn't have power of sale. Now, when you have that power of sale, I said, typically all you have to have with the power of sale is the executor or the administrator, unless there's a specific devise of the real property, okay? In which case that beneficiary must also sign the deed. All right, let me explain that. All right. What is a specific devise? All right, here's an example. Douglas made the following bequest in his will. To my niece, Dana, my home at 78 Winters Court. To my nephew, Alistair, my Rolex watch. To my sister, Tammy, all household furnishings from 78 Winters Court. These are specific, okay? So, and I hope I'm not overshooting. Cora might have this on the next slide. So say you are selling 78 Winters Court, the executor is, all right? The executor will sign, but since Dana got Winters Court in the will, gonna need her to sign too. Okay. Okay, if the will does not give that specific power, okay, what are options? All right. So say the will just says, my executor has the power to sell any and all property I own at the time of my death. All right. That's not specific power to sell real estate. That's not good enough. All right. So the options are this. They can get a court order. Okay. You see KRS 39A. That's a whole section of the Kentucky Revised Statutes. It's a whole section of the law that sets out how to sell property, real estate, okay, when there isn't specific power to do so, okay? Or, okay, the executor can come in and sign along with all the heirs and the spouses, okay? The only problem with that, I think Allison mentioned it a second ago, the only problem with that is you can only do that after 6 months have elapsed, okay? That's that creditor's deal. If you do it 6 months from when the estate's open. If you do it prior to 6 months, what the title insurance companies require us to do is issue a title policy with a creditor's rights exemption or exception, which the banks don't want and a new owner don't want. So yeah, that really can't do it, okay? Because what that means is your title insurance policy would say, hey, we're giving you good title except against any of the decedent's creditors, which if they show up, then, you know, they've got a claim on that property as well.
And Matt, just as a side note, remind them about a POA that it also needs to be specific.
Yeah, and that's specific, like what Allison said, that specific language, specific power to sell, yeah, specific power to sell real estate. You need that in a power of attorney. So if you have a seller acting as a POA or is a POA, that power of attorney needs that specific language. Okay.
And people get general POAs for their family members all the time, and they skip that specific part.
Yeah.
So they're a POA, but they don't have the right to sell.
Right. And then, or trust, if you have a trust, typically a trust needs to have that language in there. I got a little more leeway with the trust, because typically a trust will have a lot more to it. And if I can kind of decipher out from all the other powers that they meant to include real estate, I can run that by title insurance underwriters and throw myself at their feet and get them to approve it a lot of times. Because trusts aren't typically recorded anywhere. They're just there for the people. So there isn't any like way that the title insurance can get caught with their hands, you know.
And be careful on power of attorney, because it happened earlier this year. A power of attorney for a dead person isn't a power of attorney.
Yeah. I mean, think of it that way. Think of it this way. Your power of attorney, and typically what an attorney will do, if somebody comes in and says, hey, I need you to draft my will, Matt, they'll draft a will, a power of attorney, a living will directive, kind of all at once. It's kind of like a package deal. You know, they'll do all that for them. So think of it this way. What they're giving them is that power of attorney is giving somebody the right to act on their behalf while they're alive. And then the will is giving somebody the right to act on their behalf after they die. So it's kind of like your power of attorney stops at death and then your will starts. Does that make sense? Okay. Yeah, I've had that happen a lot. I had people tell me that. Say, well, I have power of attorney for him. I was like, well, he's dead. I don't think any good. So, all right. Now, some miscellaneous things about wills. All right. If it has been 10 years from the date of death, you cannot probate a will or probate an estate. Okay. And we'll kind of talk about what needs to happen then when I get to my next subject, when I go into when there's not an estate or when there's not a will. Okay. It says, what if the heirs do not want to open an estate because there are no assets except the house? Okay. What you can do at that point is it's a form with the probate court. It's called a petition to dispense and probate the will only. Okay. So what you're doing, basically what you're doing when you do that is you're getting that will recorded at the clerk's office, and then the will is passing that property. So in other words, if the only asset you have is the real estate and there's no debts, nothing like that, you really don't need to appoint an administrator or executor, because there's nothing to probate. There's no assets to wrangle. The property's there. The will sets out, you know, who gets that property, either specifically or even residually. Okay. You put that will to record in the clerk's office. That will passes the property. So in other words, say that happened with my mom. Okay. When she passes away, the only thing she has is the real estate. I probate the will only. Okay. So I do that will, they call it will pro only. It just says probate only. So I'll probate the will only. Nobody's appointed. Okay. So I go to sell the property now. All right. The sellers would be those people named in that will. all right? And you know, when you look at a deed and you see that legal description, and right below the legal description is the source of title, how they got the title. So how that would read at that closing, it would say, being the same property conveyed to Dorothy Bearden by deed dated blah, 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 and then to Matt Bearden, Pat Bearden, Chris Bearden, Becky Bearden, by will, recorded at will, blah, 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 blah. Okay. Now, the only problem with that is if one of us as children have liens and stuff against us, those liens then attach. Okay. So then when we're selling it, we're, you know, like, so this is what always happens. You have four brothers or four brothers and sisters selling the property. Three of them are straight laced, do everything right.
Always one.
Never had a problem. And then you got the one brother who owes, you have to say Capital One, he owes Capital One, he owes Chase, he owes, you know, to everybody. And then those liens attach. And basically, if it's more than his share, you know, they're eating into my share, they're eating into, you know, so to pay those liens. So,
That's crazy.
yeah, that's why it's better, you know, if, and hopefully this is nothing you guys would ever have to worry about, but if you're ever in a situation where you're thinking about an estate and you know you got that one brother who's, you know, you just open an estate. Just open the estate. It's going to cost you a little more money rather than doing this will for only. Just open the estate, have the estate sell it. The money goes into the estate and then it's distributed from the estate. And then when brother gets his share, if they all want to try to jump on him and collect the money from him, then they can, but they're not getting your share. All right. What if the will is probated in another state? Okay. So say you own property I own property in Jefferson County, but I moved to Florida. And I live, Florida becomes my domicile. And what a domicile is, it's basically you live there with the intent to stay there. So if it can be proven that that's where I live and I intended to stay there, it's my domicile. That's where they probate my estate, is in Florida. But we have to sell that property in Jefferson County, don't we? So what you do is you would open up what's called an ancillary estate in Jefferson County. So basically, my executor could come in and say, hey, Matt was a resident of Florida, but he did have this property in Jefferson County. We're opening, here's his will in Florida. We're going to set this up in the state here for the sole purpose of selling that property in Jefferson County. And then basically the estate's open, property sold, and it closes right up. Make sense? Okay. Holographic wills. You know what a holographic will is? It's a will, a handwritten will. Okay. It can be valid. It has to be solely in the handwriting of the decedent. So in other words, somebody can't type it up and then the decedent sign it. The decedent can't type it up and then sign it. They can, but it had to be proven, so it would need notaries and witnesses. But it just has to be the whole thing. Like I couldn't write out my mom's will and then have her sign it. You know, I couldn't handwrite it out. It has to all be in her handwriting. Okay.
Does that have to be notarized or you just?
No, it should be. I would do it. What they would do, I've proven a holographic will before. What you would do is you would bring in witnesses, like people who knew, say it's my mom, my poor mom. She's probably sitting there going, why do I feel like I keep talking about her now? But I would bring in witnesses who my mom might have corresponded with over the years, say like she has any remaining like sisters and brothers and send cards. Nobody sends cards anymore, so I don't know what they're going to do like when my kids' generation starts dying. They won't have. But somebody who knew their handwriting say, and you'd ask some questions like, did you know Dorothy Bearden? Yeah. Was she, did you know her on this date when she signed this will around that time? Oh yeah, I knew her then. How was she mentally? Oh, she was great. Did you see her handwriting? Oh yeah. How'd you see her handwriting? We shared letters. She gave me birthday cards every year. Is that her handwriting? Yeah. And then if the judge is satisfied, they'll probate it. I think I mentioned this. Risk in having heirs join to accomplish closing. So we're going back. When we say we got a deal like we had where we don't have specific power of sale, and I have to have the administrator sign or the executor sign, whoever, I guess it's executor in that case. I have to have the executor sign, and then I have to have the heir sign because I don't have power of sale. The risk you run into is kind of like that risk I just mentioned with the brothers. If they have liens, if those heirs have liens and they're signing, those liens attach. Okay. So that kind of, your workaround there would be, well, we got the liens. We really don't want to have them signed because we don't want to pay those liens. So I guess we got to get the court order. The problem with the court order is it takes a lot of time to get the court order. That statute I mentioned, I think it was called 389A. That statute, if you read it, to get a court order sale of real estate, you have to file, you have to notice everyone, potential heirs, creditors, everybody. When I say notice them, you have to serve them. So they have to have either sheriff serve or serve with registered mail, that type of thing. And then you have to have a hearing. So you have to go before the judge. Typically what you would do is you'd say, Judge, I have this contract for X amount of dollars to sell this property. Here's the appraiser. He says it's a good deal. Here's my realtor. You know, she's a professional in the area. She says it's a good deal. It's a good deal. And I've had situations where judges think, you know, I guess to be a judge, you got to be confident. You got to think you're right there. So I had a judge one time, and this was in disability court years ago, and he's passed away now, so I won't say his name. But I went in with all that stuff. I had the realtors with me. I had a contract. I mean, you know, what do they say in economics? Supply and demand. It meets in the middle. You got a price here. You know, what do what you need? He looks at it and goes, and I remember it was on Eastern Parkway. He goes, well, I know where that property is. That's on Eastern Parkway. No, we can do better. And I was like, so, you know, so they relisted it. Went, I think another like 6 to 8 weeks. I filed the motion again with the same deal because they couldn't get a better deal. This is in the mid-90s. Go back in there, and he was like, "Oh, can you get a better deal?" I'm like, no. But luckily, those buyers stuck it out. They wanted the property. But that's probably right. You got judges who, you know, they may want to do what they do. You know. All right. Title insurance underwriter guidelines. I mentioned when we were talking about trust. This has to do with everything. All this stuff I'm mentioning to you. There's not a lot of law on the matter. There's law in terms of, you know, how power of sale, 389A, all that stuff. There's law on that, but there's not law on how I use that information to determine whether we can close. Basically, what I have to use to determine whether we can close is what these title insurance people tell me. And we come and go with that. Sometimes they're really loose. I could go in there and say, listen, it says property in this paragraph when it talks about, you know, selling, but up here it talks about real estate. You know, can we make the leap here that they meant to say that down here? And if the title insurance underwriter's feeling good, you know, I've sent them a lot of business and they like me, maybe we can get it done. Okay, it's always kind of a moving target though. When they have a lot of claims, they're not inclined to do anything. When they go through a few years where I'm sending them a bunch of premium checks from all the closings and they're making money and they're not paying out in claims, they might be more apt to approve stuff. So anything with God, any of the stuff I tell you, I can always try to get a workaround.
Is it safe to ask that some of the stuff from back in the 2004, 5, and 6 period has come home to roost since? It's just flying stuff through that wasn't really.
Yeah, how many of y'all were in business back then, you know, 15 years ago and stuff before, you know, 2008? I mean, I used to call my title insurance underwriters, and most of them are retired now. I'd call them and say, hey, we got this, we okay? It's like, yeah, I used to make decisions myself, you know, and now I would never do that because I'm just an agent. I'm not an underwriter. But it was just so they didn't care. They were making money. There was no claims. But then once, you know, all the mortgage stuff happened in about 08, 09, whatever years those were, and went through all that period with short sales and everything, and they were losing money left and right, everything tightened up. It's loosened up lately. It's a little more loose than say it was 5 years ago, but it's still, you know, still kind of tight. Sorry. I don't want to keep y'all here all morning. If I start going too long, I'll try to speed up. Now, when you don't have a will, okay, that's what we call intestate. So you got testate with a will, intestate without a will. Okay, since you don't have a will, you know, your will tells you who gets what. Since you don't have a will, state law is going to tell you who gets what. There's actually law in the state of Kentucky. It says it governs the allocation of intestate property. Personal property is distributed according to law of the state where the deceased permanently resided. So, you know, like say I die in Florida, that determines where my personal property goes. And personal property is, you know, your bank accounts, your cars, that type of thing. Okay, furniture, all that. Real property passes according to the law of the state where it's located. So that's, you know, we talked about the ancillary administration. Okay. If no surviving spouse, no blood relatives, say you don't have anybody, the state gets it. So it's called escheatment. Okay. Typically, what happens though is, you know, you'll have, you know, if this is what happened when I was public administrator. It sounds terrible, but say a body would turn up in a morgue, you know, say at like University Hospital or somewhere, and nobody claimed it, then we would get that call. And then what we would do, and this is, you know, I would do this, we'd get, you know, their driver's license, find out where they live, go to their house, try to find a will, try to locate heirs. So a lot of that, when there's nobody around, you're spending months trying to locate heirs. And there's companies that do that, like locators of missing heirs and stuff. So the administrator, if you die intestate without a will and were a permanent resident of the state and or where your real property is located with it, and or your real properties, I can't read her, and or your real property is located within the state, Kentucky laws of descent distribution will determine who receives your property. Typically, the distribution will be your spouse and children or other family members. This is, we call it like an umbrella type of distribution, all right? I think she's got some examples. But what happens in a nutshell, if you have kids, your property goes downward to your children. If no kids, goes upward to your parents, okay? If no parents, outward to your siblings. So you can see how they call it an umbrella. It kind of looks like an umbrella. Now, having said all that, your spouse always has their dower interest as well. If you read the actual law regarding intestate distribution, the spouse is like 7th or 8th on the list. They give it to, they try to, when they wrote all these laws hundreds of years ago, they were real interested in keeping real estate within the family. Okay, and your spouse technically was not in the family, you know, not in the bloodline. So they really kind of cheated the spouse a little bit. So that's why dower came about, to protect the spouse. So you'll see children but no spouse, the children inherit everything. Spouse and children, the spouse inherits half, children inherit half, and so on. You can read these other ones. All right. How to sell. Okay, since there's no will, since it's intestate and there's no will, you basically only have those two options I mentioned earlier. When you have a will and it doesn't have the right power, you've got that court order, that 389A motion, okay, or you have them sign, the administrator sign along with all the heirs, okay. Then you have the possibility, but then you have the possibility that the heirs would have liens, and that's an issue, okay. And you also have to deal with the 6 months creditors' rights stuff, okay. There's one other way, and it's kind of behind the little notification. You can do what's called an affidavit of descent. Okay, an affidavit of descent is kind of exactly what it says it is. It's an affidavit put to record in the clerk's office, which follows the law of descent and distribution. It basically is an affidavit that says, you know, Matt died on this date. When he died, he owned property at this address. Here's the legal description of that property. And at the time he died, his heirs were his 3 children and his wife. Here's their interest, okay? One of the heirs or someone signs off on it, it goes to record in the clerk's office, okay? And once it's in the clerk's office, then that becomes the method of transferring the property. So if one of those is put to record, my heirs and my wife would be the ones who would be selling the house, and then their spouses would join on, that type of thing, okay? This here is the statute governing affidavit of descent, which I just told you about. I'm not sure why. You don't ever read it, please. What if no probate? Okay, if no probate, so say you got that 10-year deal, all right, or this happens. I mean, you would think, well, why wouldn't they do it for 10 years? This happens a lot, okay? Mom and son live in the same house together, okay? His mom's gotten older, son got a divorce. He, you know, when his wife divorced him, there was nothing he could do, so he just went to live with mom, and he's still there, you know, 10 years later. Mom dies. When mom dies, you know, the family's like, oh gosh, don't like messing with it. Son, your brother, who your brother now, you're living there, just stay there, whatever. And then 10 years later, brother finally meets someone who decides he's getting married. She don't want to live in mom's old house, so they're gonna sell the house. Well, mom's still entitled, but it's been 10 years. We can't really probate mom's estate. What do? You got that affidavit of descent, okay? Now, the only bad thing about an affidavit of descent is you have a 2-year creditor's rights. So as I've mentioned, with the estate being open, you always have 6 months creditor's rights. With an affidavit of descent, because there's no estate open, you have 2 years. Typically, though, the reason no estate's been open is because time has passed. It's 2 years from date of death. So a lot of it, believe it or not, it doesn't come into play a whole lot. Every once in a while, you get some estate attorneys who don't really look to the real estate side of things, and they think they know more than what they know. And they'll put an affidavit of descent to record, and then we'll go to sell it, and it's been less than 2 years, and I'll be like, yeah, they shouldn't have done it this way. They should have opened an estate. But most times, since time has passed, we're pretty good, or it is pretty good that 2 year doesn't bite us too much. And then also, just to compound matters, to make everything much more confusing, the Kentucky legislature, I think it was July of last year, so July of 20, they enacted a law changing all the time periods on these creditors' rights. They moved the estate one up to 3 months. They moved this one up to 6 months, but then they came in 2021 and changed it all back. So with the probate estate one, it doesn't make a real big deal because it all just depends on when your probate estate was probated. If it was started back in 2020, there's a 3-month deal, no big deal. It's better. Okay, so that doesn't really hurt us. But if you have the this one here, if you have somebody die in that year span, they might have a little better time frame. So it's kind of goofy. So all right, questions agents should be asking themselves if their seller is deceased. Seller died intestate. What do I need to effectuate the listing agreement, contract, and closing? What do y'all think? Intestate. No will. What you're going to want whoever's coming to you to sign a listing, you're going to want that document that says they were appointed administrator. Okay, so it's either it's called, like I said, a certificate of qualification or an order from the probate court appointing them.
This will come up, I promise you, in your career.
Yeah, and the order of appointment, it's basically just a little thing. It says Matt was appointed administrator of the state of Dorothy, and the judges signed it. It's dated. If you get it, if they give you something and you go, oh yeah, that looks about right, and then you want to run in and scan it to me or whoever, do it.
Let's put the side though. These people are writing an offer on a house where it's in the estate or not.
Mm-hmm.
You need to ask for this document too, because the other agent's gonna say, oh yes, they have the right to sell, but they don't know what they're doing.
Right, or they haven't had this class.
So you need to verify it because you're gonna set your buyer up to fail if they can't close on a property after they spent all the money on inspections, et cetera.
And that has happened.
Yeah, and you'll be a hero to your buyer.
Put in other provisions that you need proof they have the ability to sell.
My son, he's married, and his Mimi-in-law, she owns some really get this. I won't mention any realtors down. It's in Litchfield, but I won't mention any names. But she owns some property at Rough River, and they had somebody do a full cash offer, and he came and did a walkthrough and everything, and they show up for closing, and he doesn't show up. It's like at 4 o'clock. The buyer doesn't show up, and so he calls and says, "My bad, I couldn't make it today. I'll be there tomorrow morning." And that. So this is there at the little attorney's office in Litchfield. So they show up at 9 the next morning and sat there all day. He didn't show up. He's ghosting them. They can't get a hold of him. They finally asked the agent, agent, what's going on? And she said, I don't know. They go, well, if he doesn't come, what about, do we get his deposit? What's going on? So she goes, oh, he never gave me that deposit. And he never gave, she didn't require a proof of funds. Because I was talking to my son and said, well, did they get proof of funds? Did they do that? And she's like, no. So the agent just basically wrote them a check for the deposit. So
she got off easy.
Oh yeah. So there's always those agents out there. So just be careful.
Always.
I just was like in shock. I was like, well, maybe they don't need proof of funds in Litchfield. I don't know. So they were asking me. I was like, I'm glad I'm not. I'll tell you, I'm glad I'm not involved in this one. That was all right. Seller died with a will. What do you need? Same type of deal. You need that proof that they're the ones who are appointed, but then also you want to see a copy of that will. Okay.
Gotta say real property.
Yep, definitely. All right. What if seller dies after the contract, prior to closing? And yes, this has happened. Happened about a year ago to us. Can you close? Yeah.
You said you can.
Mm-hmm. We had Steve Frank, who's my former partner. He's retired now, but he still does a little stuff on the side. And we had the son of the seller call him. He went down. This is pre-pandemic. He went down, and so it was a little quicker that way. He went down, got him appointed. Okay. The seller had a will with power of sale. That real estate basically was still, in her estate, still had all the terms of the contract. He just signed off on everything. I mean, it was kind of a gift for him because he didn't have to deal with it because his mom had just died and it was traumatic. But he didn't have to deal with it like later. It just kind of all fell in his lap and he was done with it. It didn't drag out for him.
What if that happens and he didn't have a will?
Then we would have to do, we'd have to, either the 389A, the motion to sell, okay? Or we could have done if he's the only heir, we could have him sign as administrator and he's the heir, and hopefully he's clean. I think he was the only heir. So it would have been clean probably either way. Because if it was a lien, it was his lien. So,
You ever do like a deed upon death or whatever they call it now?
Kentucky doesn't like have transfers on death. I mean, you can word it in there. They don't have specific, like Indiana has what's called a transfer on death deed. In other words, I can put all my death, title goes to so-and-so. And then if I transfer that property ahead of time, that deed means nothing.
Right.
Okay. But if I can deed it at my death with specific language in my deed, but Kentucky, it doesn't mean nothing if I die or if I transfer it out. I would have to get the person involved in my transfer. Does that make sense? So like if I transfer to, if I put a deed record, say to my son upon my death, okay. If I go to sell it, what Kentucky says that my son has a future interest, so he would just need to sign off on his interest as well. So I'd have to bring my son into the closing.
Would it streamline it though?
It might streamline it when I die.
Yeah.
Yeah, but if I try to transfer the property before I die, it makes it a little bit, yeah, it makes it a little bit difficult. Yeah, oh yeah. Because it's just like that joint tenants rights of survivorship. It's similar language.
Put his name on the deed.
Yeah, you can do that too.
Yeah,
Mhm.
totally.
The deal is when you do something like that, obviously, when you have family members, you hope for the best. But every once in a while, things might go south. So you just want to make sure that, everything's going, because I mean, I've had deals where, at this point, 5 years ago, everything was hunky-dory, and then now they want to sell it, and one of them doesn't, they're mom doesn't know what she's doing anymore. We don't want to sell that, and mom wants to sell it, so.
I would plan on things going south.
Yeah, unfortunately. Yeah.
Yeah.
And typically what I tell people is if they're interested in something like that, they might want to just talk to maybe a trust attorney, someone like not who specializes in that. And these are expensive. The only problem with the trust is they do get expensive, but you can kind of get really specific with what you want in there versus when I just do a deed, it's just basically, we're going to do this, this, and this, and then you got to be careful with the whole, tax issues and stuff when you transfer out before death and how that's going to affect capital gains and basis and all that. All right, let's examine the following scenarios together. All right, I got about 7 or 8 of these and then we'll be done. All right, husband and wife own property as joint tenants with rights of survivorship. Spouses will everything to each other. They then divorce. Husband forgets to change his will. Husband dies. Who gets the property?
That's why.
Yes.
Let's see if we, well, no.
Ex-wife gets her half, husband gets her half. They own it as joint tenants with rights of survivorship. Once they divorce, it becomes tenants in common. Okay? And then he forgot to change everything. He forgot to change everything, so you're thinking wife gets it. No, the will, when you get divorced, becomes like if I leave everything to my wife Missy and then we get divorced and I forget to change my will, that portion of my will becomes ineffective because of our divorce. I had a deal once. I don't want to drag this out, but I had a deal once where husband and wife owned property in the 80s, got divorced in the 80s. Husband got property, set in the property settlement agreement. Husband gets property. They never did a quitclaim deed to effectuate that.
Happens a lot.
I've seen that.
Yeah. So then husband gets remarried in the 80s. Him and new wife live in the property for the next 25 years. Okay, this closing was about 7 or 8 years ago. For the next 25 years, husband dies. Wife goes to sell property. Listed with the son of her deceased husband. He was an agent at that point. We run title, see it's still in husband and ex-wife's name. Well, ex-wife says, well, tough luck. I want my share, even though she had lived there in 25 years. So my closing consisted of ex-wife had 50% interest.
Wow.
Okay, because her share. The other 50% interest, because there wasn't anything specific, wasn't a will or anything, went to new wife half. So she had 25% interest. And then ex-wife's adult children, including the realtor. And I would have thought, she lived there for 25 years. You're all adults, no, they all took their shares. They were happy to do it too. It was real awkward. It was a real awkward closing. She was in tears the whole closing, and they didn't care. I mean, he was probably dead. I told her, go back and look for him. I don't know if she did. And it's up to, technically, it's up to him, the ex-husband, he's the one who died, it was up to him to enforce that provision of the property settlement agreement. A lot of divorce attorneys don't do the deeds. I get people telling me, my divorce attorney told me to call you guys because he doesn't do deeds. A deed is like the simplest form in the world, but I just think it intimidates some people.
What really messes people up is the mortgage. They don't refinance after
Yeah.
the divorce, and it's still in both names. And really, the hard one is the second mortgage, because everyone forgets about that.
Yeah. And, you know, and then, you know, with the mortgage, this is what typically happens where I get the calls about people fighting about the mortgage is in both their names. They forget to refinance it, and then they go to sell it, pay it off. There's a escrow refund that has both their names on it. Well, they ain't been married in 10 years. You mean I got to track down my ex-wife to get this thing, you know? So, all right. Same scenario as one. What if divorce agreement says wife is the quitclaim property husband? Wife dies before she does that. I think I just kind of gave you the answer on this when I was talking about my scenario. Wife is the quitclaim, but she dies before she does that. Well, it was up to husband to enforce that, to make her get the quitclaim. If she doesn't do it, yeah. And so ex-wife's heirs still get a half. That would have been up to husband to try to enforce the contractual agreement under the property settlement agreement. All right. Same scenario as one. What if divorce proceedings have begun, but waiting for trial and husband dies?
She did it.
Yeah.
Well, other than
Well, they've been putting them in crawl spaces lately.
yeah. Well, they're still married. Okay, so nothing's severed. So all that scenario is still in place because the divorce decree. One, you're not officially divorced. Even if you filed, you're not officially divorced unless that decree says divorced. So hey, that's nothing right in talking about that. But if you have someone who says they're divorced, ask to see the decree. All right, answer not divorced. Wife gets the real estate and survivorship. What if real estate is only in husband's name? Wife still gets it all because husband's will. All right, will appoints executor and does not give them power to sell real property. The estate is open. How can the real estate be sold? We've talked about this a couple times. There's two ways, remember? You can do the motion to sell real estate, which is time consuming, long drawn out process, or administrator can sign, or administrator WWA or executor can sign, but the heirs have to join in. And what's the pitfall of that? Right. Let's see if I got it right. Yeah, I think so. Oh, we get that. No, don't forget the 6 months. Okay. All right, there's no will, no probate. I mentioned this one right at the end. The Affidavit of Descent. Okay. And that's the one where it had the long, the statute, you know, that she put in there that, you know, I told you not to read. Okay. How long from the date of death can the creditors come back? 6 months. 2 years when there's no estate. Yeah. All right. And yeah, there it is, 2 years. All right. Widow, this is where Cora gets crazy. Widow dad owns 2 pieces of property, dies with a will and 3 kids. Leaves property A to his son Aiden, other property not mentioned. Residuary leaves everything equal to 3 kids. How do you sell property A? Well, assuming will has power of sale.
Yeah.
Okay. The executor can sign off, but Aiden would need to sign because there's a specific bequest. Okay. If it's the other 3 kids, okay, with the residuary, say there's another property that falls into that residuary, and what a residuary clause is, it is kind of exactly what it says. All the rest of my stuff I give to Bluff, okay, and list. So there's nothing specific about it. It's basically anything you find goes to them. So if it's a residuary clause, that means just the executor can sign off on that, assuming there's power of sale. All right, probably will open in about a second. Yeah. All right. Husband and wife own property. That wasn't too bad. I guess this is where she gets crazy. Husband and wife own property, joint tenants with rights of survivorship. Wife dies intestate. Husband dies, and per his will, everything to wife, then 2 kids. Okay. Husband gives executor power to sell all property. Kids have lien against them. Executor sells property. Estate closes. Any problems? Okay. Let's hash this out. They own property as joint tenants with rights of survivorship. Wife dies intestate. So it's joint tenants with rights of survivorship. Wife dies, automatically goes to husband. So that intestate's a red herring. You don't have to worry about that. Automatically goes to husband. Okay. So husband owns the property. Husband dies. Okay. Per his will, leaves everything to wife, then 2 kids. So wife is the heir. Okay. But she's dead. So you got 2 kids. okay? So the husband gives the executor power to sell all property. It's not good enough, right? Okay, so kids have lien against them. So your deal is, you should have, okay, had the executor sign with the kids and their spouses and paid off their liens. That would have been the perfect world, but they didn't do that. The executor sells property, which is John Doe. So we got a bunch of issues. So title no good. Executor didn't have power to sell real property. Didn't get an order, okay? It says, can the executor reopen the estate and get order to sell? No. Once the estate closes, boom, it's gone, it's done, okay? So what you have here is you have an owner, John Doe, owns the property subject to the interests of the kids and the kids' liens.
When you say liens, I mean, are you talking about like collection liens?
Yeah,
Right,
just regular liens,
mortgages.
not mortgages. No, I'm just talking about like your general, like Capital One. You took you to court, you didn't show up, and you got a lien against you, that type of thing. Yeah.
That's fine.
Yep. So result, 2 kids must sign deed and their liens attached. So basically what would have to happen is there'd probably be a suit involving the title insurance company. And, you know, it unfortunately,
Attorney goes to jail.
yeah, hopefully not jail. I didn't know that was an option. But you know, what would probably truthfully happen is the closing attorney would get out his checkbook, pay off the liens, pay off everybody, and say, get out of my office. All right, scenario 8. This is a good one too, and hopefully this never ever would come. I mean, I've like I said, 26 years, not happen. Husband and wife own property as tenants in common, and you'll see this. And it's just an attorney or somebody drafting the deed just made a mistake. I mean, God forbid, I make mistakes too. You see it sometimes, or somebody, they might prefer it. Who knows? Just celebrated their 50th wedding anniversary. They've been married a long time. When husband dies, and in his will, he leaves a life estate to wife, remainder to wife's children. Okay. Right away, overly concerned children decide she can't reside by herself, so we'll assist her into moving into it. And she put assist. We'll get her into a retirement home. Children want to sell the empty house. The estate is still open. Okay. So what you have here, remember they're tenants in common. So wife already owns 50%. When husband dies, he leaves a life estate to wife. So in his 50%, she gets it for her life. That's exactly what a life estate is. If I leave my wife a life estate, it's basically she has the right to that property until she dies, and then it disappears. Okay, so basically life estate to wife, remainder so when it disappears, it goes to the children. So when she dies, it goes to the children. Okay, so kids want to sell. Can they do it?
Mom's still alive without her signature.
Yeah, he would have to sign. You're right. Okay. Another problem. All right. Court order from husband's estate, deed from estate, wife and all the children, correct? That's what we're thinking. No, because the way that the will was worded, wife can still have kids. Even though they've been married 50 years, she can adopt. So all her children are a class that has not been determined yet. So, you know, basically what you would have to do in this case is probably get a court order to protect everybody. Whoever drafted that will didn't do a very good job. Because, you know, I don't draft many wills, but when I do, I'll say, you know, Matt, you know, if I said my will, I'll put Matt has 3 children, you know, name them all, name their date of birth, and I intentionally omit to make provisions for any future children I may have. So there's no chance that adopted kid, you know, if I'm married for 50 years, there's no chance I'm adopting. Because let's see, that would make me 75 if I make it to 50
What
years.
about the long lost one that you didn't know about?
I mean, that's the issue too. That person, though, it's up to them to prove. So, you know, they would have to come in and prove theirs, and then that could be definitely, that happens though. That's
That DNA stuff.
yeah.
Yeah.
My uncle or my brother does all that Ancestry.com. And he got a call from a woman. My brother is 7 years older than me, so he's like 58. He got a call from someone his age in Seattle, and it was my uncle's. God, I shouldn't say that. Y'all know my last name. It was my uncle. I'm sorry. It was a woman. When he was in the army in the 60s, she was his daughter.
Long lost sister.
Yeah.
Cool.
Yep. So something like that, you almost got to get court order to say, hey, judge, you decipher this. you know, and that way, because what you do with that court order is you basically put out notice to anybody. And so technically it's on anybody like long lost heirs, it would be on them to kind of show up.
Every now and then you see that in the Courier Journal, looking for the
Yeah,
heirs of
there's
such
companies-
and such estate.
Like when I was at the public administrator, we had a contractor we used, and that was the name of her company, it was Locators of Missing Heirs. I don't know if she's still in business, but that's what she did. That was in the 90s. It's totally changed now. I'm sure there's people who can just sit in front of a laptop and do all that. Okay. Oh, that's our last one. That's my last one.
Real quickly, one of the things I preach around here is whether you're gonna list a house or sell a house, you start with the PDA to see whose name's on the deed.
Yeah.
And there's a hyperlink in there. You can click on it and see.
Yeah, and PDA does a pretty good job. You know, it might take a little bit of time, but when a property ends up in the estate, they usually will note that, you know. So it might take, you know, it might not happen instantaneously, you know, when that will is put to record, but you know, usually within a couple months, it'll pop up on there. And truthfully, if somebody's coming to you and say, hey, mom died Thursday, we want to get this house sold, they're probably a little premature. Okay.
Probably something going on behind the scenes.
Yeah. So those ones, you know, make sure you dig in a little bit, ask some leading questions, find out what the heck's going on, you know. And obviously this stuff, I've done this a long time, and I stumbled over stuff, and had to back up and say, wait, let me explain this better. There's no way, you know, you guys got enough to worry about with what you do that you can know this. Just know kind of what indicates what, you know, when this happens, this is what I should look for, you know, that civic qualification, that order appointing, what the will needs to say, where to locate it in the will. Now, if you're looking for classes at GLAR, if you take this class, one of the things we do is we kind of put some redacted wills together and give you a chance to kind of look through those and kind of look for the language. Truthfully, the problem is, you know, how many times you probably do this in your career where you have an estate? You know, probably not a ton where you'll be representing an estate. Like I see it a ton because this is what I do. I just see it in volume. But once you do it once or twice, you'll pretty much have a good handle. It's like kind of like once you see one will, you've kind of seen a lot of wills. Okay,
My biggest fear is when we're representing the buyers.
Yeah.
Because I think they're pretty good on doing all their homework on the listing side, but we're too trusting of the other
Right.
realtors.
And
That's not a good.
like I was talking about the agent Litchfield, don't assume, man.
Right.
You know, I don't want to say anything bad about anybody, but there's a lot of people out there don't know what they're doing. I'd say there's probably more people out there don't know what they're doing than people who do know what they're doing.
Well, let me
Okay.
ask you real quick, when you say like the kids want to sell it fast, my neighbor died a few years ago, and I actually found her, and through that, I got to know the family, I sold the property, she got intended. The son, the nicest guy in his 30s, really didn't have the money, you know, at the young family to make her mortgage and keep it going.
Right.
They got it done pretty fast, but they have to do all that, right?
Yeah.
I mean, they have to keep the lights on, they have to pay
Yeah.
the mortgage. So,
Yeah,
you
it's
know,
tough.
a lot of times they need to get more.
Yeah, and the thing is too, a lot of these states I'll see is, you know, you'll look at those payoffs on the mortgages, and typically there'll be a lot of past due stuff, but what they haven't done is haven't filed foreclosure. So I think a lot of mortgage companies might work with you. You know what I'm saying? If you kind of tell them what's going on, they might work with you a little bit. Okay.
Any other questions?
Thanks, guys. If y'all need anything, just let me know. Okay. Thanks.
Thank you.
It was a great class.
Always great.
Sorry, I didn't give Morgan a chance to talk, but next time.